Ramsepidi, any other questions to this witness?
As the court pleases, my lord, I don't have any further questions for the witness.
Right.
As the court
Yes,
pleases.
Mr. Nisi, any questions?
As it is a court, I indicated yesterday that I don't have questions to this witness.
Yes, Mr. Ngumalo, any questions?
Thank you, my lord. I have no questions to this witness. Thank you.
Mr. Cholo?
Thank you, my lord. I don't have questions to this witness.
Okay. Have you brought that information, which I said you should bring in about 10 days' time?
Your Lordship, unfortunately,
Oh, you couldn't.
I was too late to, but I have requested it this morning.
Okay,
And
okay.
the court will have it in due course.
Okay, fine. Okay. Okay, you're then excused. Thanks. Yes, Mr.
As a court, please, my lord, before we adjourned yesterday, the state had just handed up Exhibit DD, in brackets 1. It's an affidavit in terms of Section 236 of the Criminal Procedure Act 51 of 1977 that pertains to the bank records of Mr. Bongani Ntanzi, and the state wants to continue with that.
Have you supplied the other councils with this?
That process, yes.
All of them? All of
yes,
them?
Yes.
All of them?
Yes, all of them.
Okay.
My learned colleague, that you are going to object to this exhibit being read in record at this point in time for the following reasons, my lord. The court will recall that we asked specifically for this information because I was given instructions that on the 25th of October 2015, specifically, there were certain transactions showing and indicating that they were done in Nongoma by accused number 2. And when we look at the records furnished to us, those records are not reflected in this statement. Unfortunately, due to financial constraints, I cannot hire a forensic chartered accountant. However, I've endeavored with a friend of mine, that's not in a personal capacity, because she works for one of the institutions where a certain transaction is alleged to have happened. So she said she will ask her company whether she can access the backdated bank records of that specific date to see whether that swiped transaction appears on their bank records. So, my lord, I feel that until we have ventilated and corroborated or otherwise that information, reading this into record, my lord, will put me in a corner whereby, as in a 212 statement, if I accept it now, I accept it for its correctness and truthfulness, and later on I'll be squeezed in a corner to say, by the way, I have established that there was a transaction, so I need to come back to court and explain why now I need to explain that transaction at that stage. So it doesn't, my lord, I think, detract from the state's case to put this information later once we've ventilated those transactions, my lord. As the court pleases, that's my submission.
Yeah, Mr. Balui, what's your view?
As a court please, my lord, my learned friend submitted that if he accepts the exhibit, he'll be bound by the contents thereof. He doesn't have to accept anything, my lord. At this stage, the states want to hand up this document in terms of Section 236.
Just read 236 so that we all know what you're talking about.
And we submit, my lord, that the document is on all fours with the provisions of Section 236. It reads as follows: proof of entries in accordance in accounting records and documentation of banks. Subsection 1, the entries in the accounting records of a bank and any document which is in the possession of any bank and which refers to the said entries or to any business transaction of the bank shall, upon the mere production at criminal proceedings of a document purporting to be an affidavit made by a person who in the affidavit alleges, firstly, that he is in the service of the bank in question. Secondly, that such accounting records or document is or has been the ordinary records or document of such bank. Subparagraph C, that the said entries have been made in the usual and ordinary course of the business of such bank, or the said document has been compiled, printed, or obtained in the usual and ordinary course of the business of such a bank. And D, that such accounting records or document is in the custody or under the control of such bank. B, prima facie proof at such proceedings of the matters, transactions, and accounts recorded in such accounting records or document. Then subsection 2 of the section provides as follows. Any entry in any accounting record referred to in subsection 1 or any document referred to in subsection 1 may be proved at criminal proceedings upon the mere production, and the emphasis here, my lord, falls on upon the mere production at such proceedings of a document purporting to be an affidavit made by any person who in that affidavit alleges that A, that he is in the service of the bank in question, B, that he has examined the entry, accounting record or document in question, C, that a copy of such entry or document set out in the affidavit or in the annexure thereto is a correct copy of such entry or document. Then subsection 3, any party at the proceedings in question against whom evidence is adduced in terms of this section or against whom it is intended to adduce evidence in terms of this section may, upon the order of the court before which the proceedings are pending, inspect the original of the document or entry in question and any accounting record in which such entry appears or of which such entry forms part, and such party may make copies of such document or entry, and the court shall, upon the application of the party concerned, adjourn the proceedings for the purpose of such inspection or the making of such copies. So subsection 3 gives the party against whom the document is sought to be used the authority to approach the bank to inspect the originals of the entries. We therefore submit, my lord, that bank records are upon submission, prima facie proof of the transactions recorded therein. We therefore, my lord, submit that this document ought to be, at this stage, accepted into the record as evidence, as prima facie proof of the transactions that are recorded in this exhibit.
Yeah, just for my edification, this record, which purports to be a true reflection of the banking details of that particular account, starts from which date? Is it from the inception of the account being opened or what?
The statement is for the period 25 October 2014. 25 October
2014.
Yes,
Right.
to 28 October 2014.
And it's in respect of one account, not various accounts, just only one account.
Indeed, my lord, but I see if one looks at the transactions,
Yeah.
they actually cover the period 31 January 2014
January 2014, right?
up to 31 December 2015.
2015, okay. So, Mr. Musipili, what is the objection?
My Lord, as I state, my instructions are this. Accused number 2 states that he had certain ceremonies to perform. Therefore, he obtained a loan from this bank, Capitec, to do the work that he was supposed to do. Firstly, we've gone through this, and an accountant has gone through this as well with me. We don't see that loan amount reflected
If
here.
it's not here, then it was never made with a bank. What bank is it? Where you make a loan and it's not reflected in an account. It must be in another account.
That's the
I mean, this is simple accounting principles.
Yes,
If you make a loan against an account,
yes.
it must be reflected in that particular account unless you make it in another account of a different account number. Then I can understand. Now,
That's-
are you saying that loan was made in respect of this account? What's the account number? They just give us the account number. What's the account number? It says Capitec.
Yes, it's Capitec, and
Account number?
the account type, it's a savings account.
Savings
And
account.
yes, the account number is 135 64 12 988.
Now, Mr. Namasipili, your client, you can take instructions. Did he make a loan against this account number?
I did verify that, my Lord, that at that time, Capitec had only this type of account, that is the savings into which the loan was deposited. Because I thought also there's perhaps a loan account into which it was placed.
My question is,
Yes.
was the loan made against this account 1356412,988?
I can verify that, but
Yeah, please.
I had previously taken it.
Because I can't understand, these things are electronically done. It's not like counting sheep in a crawl.
As it pleases the court, my Lord, I mean, that had the very same instructions, my Lord, that he only had one Capitec bank account into which the loan amount was deposited. And like I'm saying, it's not reflected on the statement. And also, if we
When
look,
was it deposited? Because according to the state, this account became operational from the 31st of January 2014 to the 31st of December 2015. Was it that loan made during this period?
let me take instructions, my Lord. Lord, perhaps if I ask for a 10 minutes adjournment so that I can fully take instructions rather than go up and down.
Yeah, fine, but listen to what the bank says.
Yes.
And this is a savings account statement to your client, dated the 6th of September 2023. No transactions for the statement period selected. Transactions not yet processed on your account up to the 28th October 2014. There are no unprocessed transaction items. Transactions before the 1st of April 2018 amount inclusive of 14% VAT. Transaction from the 1st of April amount inclusive of 15% VAT. Checks not yet processed on your account up to the 28th of October 2014. There are no unprocessed check items. And then they tell you the available balance.
Yes, I have gone through that with him, but let me finalize instructions, my lord, then we'll come back.
Okay. 5 minutes. an accused person to accept evidence if he doesn't want to accept it. You have a right to challenge this evidence. This section says this is prima facie
Yes.
evidence.
Upon being challenged.
That's it, yeah, you can challenge it. But you can't stop the state from leading this evidence on the basis that there is no loan, which is depicted on this statement. You've got the right to subpoena Mrs. Brink, and you've got the right to request the records of your client, and you've got the right to contest the veracity of those records. Okay.
Indeed, so, madam.
Yes, Mr.
As a,
Baloyi, fine.
as the court pleases, the essence of this exhibit, this document, appears on page 2,
Page 2.
under paragraph 1, that there were no transactions on this account for the period 25 October 2014
Wait, period 25 October 2014.
to 28 October 2014.
No transactions.
Yes.
Okay.
Mshushisi uthi-ke Mr. Ntanzi akufundayo noma-ke ku-page 2 wale document-ke yasebhenki ayifundayo ukuthi upage 2 wakhona uthi ukusuka ngazo i-25 zika-October 2014 kuze kuyoshaya i-28 zika-October 2014 akukho okwenzeka kuyona le account noma akuna transaction eyenzeka ngaleso sikhathi leso.
Yes.
As the court pleases, my lord. As indicated yesterday, my lord, the state is now at a point where we want to present the various statements made by the accused persons. The state is in possession of a confession as well as the pointings out made by accused number 1.
Kulesi sigaba ke umshushisi uthi bewumbuso ke bafikele kwisigaba lapho namanje befuna ukuthi ke bothuleke izitatimende ezenziwa ibona abasola lokubiza ukuthi ke confession noma ukuvuma ke kanye futhi nama pointing out ukukhomba okwenziwa uyena uaccused number 1.
The state is also in possession of 2 confessions made by accused number 2.
Kanye futhi ke nama confession noma izitatimende ke zokuvuma noma ke ukuvuma ezenziwe uyena uaccused number 2 ezimbili.
The state also intends to lead evidence on the warning statements of all the accused.
Kanye ke nama statement noma lokho kubizwa ke ukuthi ke ama warning statement izitatimende ke zokuxwayiswa ezenziwa ibona bonke abasolwa.
As far as the confessions are concerned, I've been informed by Mr. Ramusipile that the admissibility thereof is being challenged on various grounds, which they will in due course advance.
Ushilo ke u-advocate Ramusipile noma ke umeli uRamusipile ukuthi ke iqiniso ke elikhona ke kulezo izitatimende ke ekuthiwa zenziwe ibona ke abamangalelwa noma abasolwa abamele uzophikisana ke nabo.
And that applies to the pointings out as well.
Kanye nalabo kushiwoyo khona ke ukuthi ke ummangalelwa wakhe uqala wahamba wayokhomba khona.
As far as the warning statements are concerned, the position is not yet clear. I'm yet to be informed by my learned friends what their position is regarding the warning statements.
Mayelana nale izitatimende lezi ezithathwayo ke uma abasola beboshwa lokubizwa ukuthi ama warning statement ke angikazi ke ukuthi lapho ke kuzokwenzekani abameli abakangitsheli.
But be that as it may, the state will request that one trial within a trial be held regarding the admissibility of all these documents as the evidence is interlinked.
Wait.
Sorry.
What are you saying now?
I'm saying that when we get to that stage, my lord, we will request that one main trial within a trial be held to determine the admissibility of all these documents, my lord.
I know no law like that. Because the confession doesn't bind a co-accused, as you know. Is that not
Yes,
so?
that's indeed so.
Yeah, so if there's a conflict, for instance, in that regard, what does the court do?
Yes, but what we mean is, for instance, my lord, we are avoiding a situation
Yeah.
where we determine the admissibility of accused number one's confession. We hold one trial within a trial.
Right.
Then we go to accused number two,
Right.
determine the admissibility of that confession,
Right.
hold another trial within a trial.
Yes, that's how it has to be done.
Yes, we're trying to avoid that piecemeal way of holding a trial within a trial, as we pointed out that the evidence is interconnected, my lord. So if we hold just one trial within a trial, we will then avoid the situation where we hold the trial within a trial in compartments, my lord.
Now I hear you. So you want to hold one trial within a trial in respect of all the affected accused?
Yes, indeed, my lord.
Regarding the admissibility of whatever,
Yes.
pointing out of statements. Or,
Indeed, my lord.
okay, let's just read what are your duties so that we understand it. This is the do it. It's not me saying this. Duties of the prosecutor. It is, in fact, the duty of the prosecutor first to investigate the circumstances under which the statement was made and to establish whether it amounts to a confession or an admission. They quote the case as Bonzi, 1985-4, SAA 544. If the prosecutor is in doubt, it is his duty when raising the issue in open court to warn the presiding judicial officer, who must then investigate first whether the accused made the statement, and if so, whether it is a confession or not. So let's pause there. Mr. Ramsipidi, your client, has he just made a statement, or has he made a confession, or has he made admissions?
My lord,
I know we are disputing the admissibility
Yes.
of them, but what are you saying?
it's a statement, my lord.
Now, but listen to me carefully.
Yes.
Has he made a statement? Or has he made a confession?
Yes.
Or has he made admissions?
My lord, let me clarify from my perspective. My instructions are that he never made any statement.
Yeah, so you must tell me that.
Yes,
So your client denies that he made a statement.
indeed so, my
And
lord.
he also denies that he made a confession.
Indeed so, my lord.
And he also denies that he made admissions.
Yes.
Okay, fine. Right, this fellow said it is appropriate for the presiding officer to conduct a preliminary inquiry to determine the nature of the statement before a trial within a trial is held in respect of the further questioning relating to whether the statement was freely and voluntarily made. You hear what they say? You say your client never made a statement,
He never made a statement.
as juxtaposed to say the statement which the state alleges your client did make was not freely and voluntarily made, it was coerced. You're not saying that. Just think about the law.
My lord, this is the position, as I was explaining. The making of the statement needs to be clarified because he says a statement was brought to him, he was assaulted, coerced to sign that statement.
Okay, fine. I hear you. As opposed to saying he never made a statement. When you say he never made a statement, it means no statement was made by your client. He can't make a statement because he was coerced to have made a statement or forced, as you say.
That's
So
exactly.
what are you saying?
My lord, this is the position. He made a statement because he was beaten up, assaulted,
That's it.
abused
Yeah,
to
fine.
sign that statement.
Okay, fine. Now appreciate it. Okay, fine. Okay, and then the law says, it is appropriate for the presiding officer to conduct a preliminary inquiry, as I'm doing, to determine the nature of the statement before a trial within a trial is held in respect of the further questions relating to whether the statement was freely and voluntarily made, particularly where the parties are in agreement that the nature of the statement may be determined from the document alone without recourse to the evidence directed at its proper construction. But you say it was never made freely and voluntarily.
Indeed so, my lord.
Okay? Yeah. Okay, my former colleague, Salduka, in the case of S versus Gamma, 2013, it's an SCA case, unreported. Case number 127/13, delivered on the 27th of September 2013. This is what he has to say, among other things. That the court is obliged to tell the presiding officer whether in fact it is going to conduct a trial within a trial. And this is how he points out it wasn't done in this case. He says, it is a disquieting feature of the appellant's conviction. The trial court had relied on a confession made by the appellant, but the prosecution had at no stage told the court that evidence of a confession would be led. But in this case, you are saying you intend leading evidence of a confession.
Indeed, my lord.
Okay? They say if you don't tell the court that, it amounts to a fundamental miscarriage of justice. And if there was any doubt as to whether the appellant's statement amounted to a confession, the prosecution was duty-bound to inform the trial court accordingly. A preliminary inquiry should then have been held to determine first whether the appellant had made the statement, and if so, the nature of the statement. Whether that is, it amounted to a confession. If it was found to be a confession, a trial within a trial would have had to be held to determine the admissibility of it. And it would consequently would have been for the state to prove the requirements for admissibility. The prosecution's failure to comply with its duty and the absence and the statement, its admission in these circumstances offended against the appellant's right to a fair trial. Where, as we know in our law, a trial, our law demands that a trial be conducted in accordance with the notions of basic fairness and justice. We are quoting the case of State versus Zuma. It's a judgment by Kentridge. Right. I had to read this because I must satisfy myself that either a statement was made or either a confession was made. And this relates also to a pointing out, because it is a genus of a confession, a pointing out, and can also amount to an admission. Okay, so I'm satisfied then that your client, according to, alleges that he didn't make a confession, but the state alleges that he did make one. Then you need a trial within a trial to enable the defense to contest the admissibility of that statement or confession. Okay, right. That pertains to accused number 2's position. And accused number 3's position, if any.
Yeah, it's, as we mentioned, it's accused number 1, there's a confession and a pointings out.
Yeah.
And accused number 2, there are 2 confessions.
Right. And number 3?
Number 3 up to number 5, those are just warning statements.
Warning statements, okay. Fine, so the trial within the trial will encompass accused number 1, 2, and 3. Sorry, 1 and 2.
Yes, 1 and 2.
At this stage?
Yes, and I also request that the warning statements, if they're going to be contested, that they also form part of the trial within the trial.
Okay, fine. We'll come to that when we are through with Mr. Ramasipidi. Right, so the basis of your defense regarding the admissibility of the statement allegedly made by your client, it's what, Mr. Ramasipidi?
My lord, are we at that stage?
Yes, we have mentioned assault. I must know, on what
Yes.
basis are you contesting it?
My lord, let us take a short adjournment for that.
Why do you want a short adjournment? Because the law is clear. You tell
Yes.
the court, for instance, you've told this court that your client was coerced into making a statement by being assaulted, right?
Yes.
Any other reason?
My lord, let me speak individually. Accused number 1, he was assaulted
Yes.
over a period of time.
Right, I'm writing, by the way, right?
Okay, yes.
Number 1 was assaulted over a period of time.
Yeah, he was arrested on the 16th of June 2020.
Okay, wait, 16 June 2020,
Yes.
and assaulted.
No, he was assaulted from the 19th of June
Assaulted from the 19th of June
2020
2020.
until he was taken to court in.
Yeah,
My lord, that's why I say we must take a short, because the consultation is written in my notebook. So,
Okay.
yes,
How
let's
long?
take a short adjournment. 30 minutes, my lord.
okay, what's your time there, Mr. Balwe?
It's 11 o'clock, my lord.
11 o'clock?
Yes.
So we come back at 11:30.
Indeed, so my lord.
Okay, 11:30.
The person that my learned colleague spoke to, it's me in particular, not the rest of my colleagues. And the tentative suggestion was for Friday.
Friday is tomorrow.
No. Monday. Sorry, madam.
My apologies, my lord, to interfere. The canvas has not been discussed with us, my lord. If we can just have a word together, because we have never been informed about that, my lord. Just a minute, my lord. My apologies.
But every council here knew that today Mr. Baloyi was going to commence with
Trial within a
what he
trial.
calls a trial within a trial. All of us knew that. He
Yes, my lord,
broadcasted
I'm
it.
surprised about the request of the postponement. That's
Yes,
what I need to
I'm
get
also
clarity on.
surprised.
Yes.
Because these statements, I'm sure you must have heard them in 2021 when my colleague was handling this case, Judge Maumel.
Maumel, yeah.
You heard the
Your
statements.
brother, my lord.
2021.
My Lord will recall at the beginning of this process, I expressed amazement to say, are we at that stage? Because I had previously discussed with Mr. Baloyi, and we were going to postpone this matter so that I consult fully for the purposes of a trial within a trial. And we were debating dates up and down. I said we are waiting for Ms. Mushololo because I haven't taken full instructions for the trial within a trial, my Lord. And that was the suggestion that we are going to postpone. And Mr. Baloyi even suggested yesterday that we may commence the trial within a trial on the 1st. That was my understanding, but I said let's wait so that we can canvass everything because Advocate Munisi had indicated that he's not available next week, and my colleague Advocate Mushololo.
Why is he not available, your colleague, next week? Let me tell you, I had discussions with the JP concerning this matter, even
Yes.
with DJP.
Yes.
This case, you don't need to have Mandela's wisdom. This case, the cause of action in this case allegedly occurred on the 26th of October 2014.
Yes.
2014. If you come with a request that you want to abandon this case and do another case, you must compare the circumstances. 2014, this case, 7 years,
9 years
on the go. Everybody who knows anything about time knows that this case happened in 2014.
Indeed, so, madam.
Now, I'm not saying you are saying you want postponement because of whatever reason. So if this case must be postponed, you must tell me that we are dealing with a case which happened in 1902. Fine, then we are talking. It must have preference over my case because my case allegedly happened in 1902. And this one happened in 2014. So that one enjoys a privilege of time because it's longer on the roll than this one. If you come with a reason like that, it makes sense. But you can't tell me you want to finish a case which started 8 years after this one. To me, it doesn't make sense. Doesn't make sense. And the JP agrees with it. Doesn't make sense.
On that aspect, my Lord, I cannot speak for anyone.
No,
That's
anybody
correct.
can chip in.
I think, perhaps, my Lord, with regard to this short postponement, for the purposes of me taking instructions for the summation of the objection for the admissibility of those confessions, I'll need a day or 2 days, but my colleagues will chip in, my Lord, with that respect.
Yes, Mr. Minister, how many days do you need? Oh, we don't need any days.
In respect of what?
He says you may chip in. He wants a day. You said you wanted a day.
Indeed, so, madam, I said maybe
A
until
day.
Friday, but
And then, Mr. Minister, how many days do you need?
In respect of the preparation for the tragically trial.
We don't need any days.
No.
Thank you. Mr. Ngomalo?
I also do not need anything.
Right. Mr. Msholos?
My lord, I also don't need anything.
So it's only you, Mr. Ramsepidi. You need a day to prepare.
indeed, so, my Lord.
You haven't prepared in the past.
I have consulted several times at prison, my Lord, for the main trial.
A trial within a trial is the main trial.
Yes, indeed so, my
What
lord.
has changed?
Even last week I was at various centers consulting with accused number 1 and 2. Yes, but we say we need certain clarity on certain matters, my lord.
So today is what? Thursday? Is it Wednesday?
Wednesday.
Wednesday. So we should adjourn until Friday, according to Mr. Ramosipiti.
It's fine. Yes.
Is it okay? The JP is worried about the pace this trial is taking. He is saying, and I'm saying it public, he's saying this trial, the way it's proceeding, there are other trials which are awaiting this gentleman, for instance. He sees with other trials. They've all stopped because of this trial. That's why this trial is of the essence, in the sense that it has paralyzed a judge, a prosecutor, and even some defense counsels because of what the JP says. There are cases which, as you all know, are waiting to be on the roll. So it's not like me who's saying all these things. When there's a postponement like this, he wants to know what for. Kanti labantu laba angithi kade bakumawumela. So azange ubani uyabanike ama statements 2021. What do I say to that? Then I say to uthi banikile, but Mr. Ramosipiti says he wants to prepare. Since 2021 he has never prepared. Is that what you're saying?
I was not in this case in 2021.
2022 or 2022?
Also, let me play something on record.
Yeah.
And I can show the copy if those dates are here.
What do you want to show me?
The previous confessions that were given to me were on faint paper like this one, which I can't make head or tail. I requested my learned colleague yesterday to furnish with clearer copies.
So since
No, I had prepared based on...
Yeah, but you're saying since
Yes.
you got instructions, that document was faint. You couldn't read it.
It is faint. I tried my level best to do it, but then I got clearer copies this morning, my lord, a package this morning.
Okay, fine. Okay, let's adjourn then until Friday. For the reason that Mr. Ramosipiti wants to prepare for the trial within a trial. Where are your witnesses? Are they here, Mr.?
They are available, my lord. They are available.
So they are not here, they are available.
Yes.
Hello?
There were no witnesses scheduled for today, according
Is
to
that so?
our regulations.
How was he going to start the trial then? Within the
Exactly my
trial?
point, my lord. There were no scheduled witnesses.
Well,
We were
my
never
lord,
told who's coming.
the defense should not speak for ourselves. We make arrangements with witnesses who are just a mere phone call away.
Oh, is that so? Do you know that you can make a call to the planet Mars? Hello? Okay, tomorrow then. It's
Friday.
Friday. Okay.